And Ms. Bernal, you are the appellant, correct?
Yes, sir.
All right. Do you want to reserve any rebuttal time?
5 minutes, please, Your Honor.
You got it. All right, let's begin.
May it please the court. Good morning, Your Honors. I'm Sherry Bernal, attorney for the appellants Mack and Crow. The trial court denied our statutory claim for attorney's fees, and we are here asking you to reverse that decision and grant the appellant their fees. Since this involves the interpretation of a statute, the review is de novo. Any reference that I make today to the act is probably going to be a reference to the Condominium Act, which is Florida Statute 718, Florida Chapter 718 under Florida statutes.
Is there any doubt that this is a subrogation act under the Condominium Act?
Well, the Universal says that they did not bring the action underneath the Condominium Act. That's their basis for why they say
that's the whole gist of it.
The crux is whether or not they brought the action underneath the act.
Right.
And we allege that they have, based on their the plain reading of their pleadings, as well as their answers to interrogatories.
Yeah, I was a little confused by that, and maybe your opponent is the proper party to ask, but if the original claim was brought under the Condominium Act, what is the argument that it wouldn't have to be that it's a common law subrogation action and that the fortuity or the happenstance of the Condominium Act doesn't play any part in this?
Their argument right now is that Loftus, the case that was decided against the same plaintiff, relieves them from themselves. It says that there is no private cause of action underneath 718.111.11J. However, they disregard the case law that says as long as the plaintiff has brought the cause of action pursuant to the act, even if the act is held to be inapplicable or a different state's law applies or any other reason, as long as the plaintiff brought it pursuant to have their attorney's fees if there's a prevailing party statute in that act, which is what we have here.
Aren't they also making an argument separate from that argument? So that argument is based on Loftus, and they're saying, well, since the court said there is no statutory cause of action, there's no way we could have ever brought it. And you would rely on case Diamond Aircraft, which says, well, that's your problem. You brought it under an act that doesn't provide you cause of action, but you still invoke what you thought were the benefits of the act, and therefore you suffer the risk. But didn't they also bring a separate argument that you probably need to address, that even independent of the Loftus decision, they weren't using the act as a basis of the cause of action, but rather to, and I'm just hopefully quoting their argument accurately, I'll be corrected if not, but rather just establishing the vicarious liability. And so I have two questions for you. One, is there another way they could have established vicarious liability? And two, how does that affect your argument that they're still brought this under the act?
Okay, I do not believe that there is any other way that they could have established the vicarious liability of the tenant and or the plumber, which are the allegations that they make in their complaint, as well as in their sworn answers to interrogatories.
So does that hurt your argument or help it? The fact that
I think it helps it
they couldn't have brought vicarious liability. In other words, so that they were saying, well, this is just icing on the cake. We're just trying to help ourselves out by saying, here's the linkage. We're not bringing it under the act.
Right, but the linkage doesn't make sense unless they're trying to prove vicarious liability. What would be the reason to even allege vicarious liability under the act if they weren't trying to attach someone else's negligence to the defendants? It gave them two different bites at the apple: the defendant's negligence as well as the negligence of the invitees. Through the plain language that they used in their complaint, as well as the plain language they used in their answers to interrogatories, they were clearly trying to attach liability to the defendants for someone else's negligence. They didn't allege that they negligently hired the plumber. They didn't allege that they negligently supervised the plumber. They alleged, and I quote, "There is active negligence appears on the part of the installer of the water heater since the pipe was not properly soldered. Defendants are responsible for the negligence of the installer/invitee pursuant to Florida Statute 718.111. So for them to now say that this is just a common law cause of action when they've clearly alleged vicarious liability pursuant to the statute, in their own words, pursuant to the statute, I don't see how they can say that this is just a common law cause of action.
Which argument was convincing to the trial court? The Loftus argument that, well, you know, there is no cause of action under this statute, so therefore they couldn't possibly have brought it under the statute, or the argument that, well, just because we're creating a respondent superior linkage, that doesn't mean it's under the act.
I'm sorry, Loftus was not brought up at the trial level because it hadn't yet been decided.
Oh, that's right. That's right. Thank you for reminding me of that. I apologize.
When this complaint was filed 2 years ago, at almost the same time, they filed the Loftus complaint alleging nearly identical allegations. The only difference is that they also sued the tenant individually. Here, they only for the negligence of the tenant, and they use 718-111 for that purpose.
You answered my question by reminding me that that Loftus did not come up at the trial level.
Okay.
Is that right? It didn't come up at all. It
didn't come up at all. It hadn't been decided yet. When we argued this, it was back in June.
The fees had already been denied when Loftus was decided.
Yes.
Okay. Sorry about that. Thank you for reminding me. Go ahead. Sorry.
Okay. So again, based on the plain reading of their own words, there is a duty there that they created, or rather that the statute created, that they relied upon to try to impose vicarious liability on the defendants. Now, plaintiff alleges in their answer brief that there is no duty in the statute. Well, according to the 4th District in Loftus, it says, without question, by using the language, quote, responsible for the costs, the statute imposes a duty on a unit owner to be responsible for the cost of repair or replacement of any portion of an innocent unit owner's property not paid by insurance proceeds if such damage is caused by intentional conduct or negligence of the former's tenants. However, the existence of a statutory duty does not answer the question of whether a breach of that duty would give rise to a private action. So ultimately, Loftus held there was no private action, that this paragraph taken as a whole in power material the association's ability to levy an assessment against a unit owner for the intentional and negligent acts of third parties that they're ultimately responsible for. It does not say that, I'm sorry, I lost my train of thought. So going forward, I'm sorry, did you have a question? I can't hear Judge Atkinson.
Yeah, Judge Atkinson, your volume went out. If you want to type the question, we can ask it for you. Okay, he said move on.
Okay. Appellee actually admits in their answer brief 3 different times on page 6, on page 10, and pages 2 to 3 that the appellants were liable to Universal because they or their members of their family, unit occupants, tenants, guests, or invitees negligently failed to maintain, repair, and inspect various plumbing, and that defendants were liable for the negligence of their guests, visitors, or invitees by operation of Florida law, and specifically section 718-111. Goes on to say the only mention of 718 in the amended complaint was to establish defendants' vicarious liability for the acts of others. Finally, it says in its answer brief that it used the act to establish the vicarious liability link between the appellants and their tenants. Again, there's no common law cause of action that allows the defendants to be liable for third parties' negligence. But for the use of the statute, they wouldn't be getting anywhere near vicarious liability. So plaintiff also argues that Continental Casualty requires a written assignment. We have to respectfully disagree with that. The bottom line on Continental Casualty is it has nothing to do with contractual subrogation and a prevailing party statute.
Let me stop the clock for 1 second because I see the video of Judge Atkinson has stopped. Judge Atkinson, can you hear us? Let's pause. All right, he's talking now. Is that, I couldn't hear you, but it popped up on the screen. Are we better on your end? Still having a technical issue. Let's give it another few seconds here and see what's going on. All right, you says you're talking, but we don't hear you. And we don't have your video. Okay. And we're getting some static, so I don't know if that's a good sign or just more problems.
IT is down there with him, sir.
Okay, so let's just wait a second. It also shows his video is off according to the participant queue. Now he's not even on as a panelist.
Yeah, they disconnected. I'm going to try to bring them back in, sir.
Okay. All right. Well, let's stand by. I stopped the clock, so you've got 10 minutes and 37 seconds left if you want to prepare the rest of your argument. And Ms. Gregoire,
Judge Valenti, can you hear me?
I hear you fine.
Okay.
How's IT doing?
I just left the meeting and signed back on, and that seems.
Well, if we can't get this thing going in a minute, I think what I'm going to suggest is we plow forward with the.
I'm good. Can you hear me?
Judge Atkinson can always watch it. Yeah, now I hear you. I even see you. Voila. Okay.
Thank you. Sorry about that.
That's not your fault. We appreciate the IT department here. So I'm going to start the clock. And Ms. Bernal, you've got the time left I just indicated, 10:37. All right, ready to go? Here we go.
Thank you, Your Honor. Yes. Okay, so let me back up just a little bit. This case involves subrogation. It involves contractual subrogation, not equitable subrogation. There is a difference with that. Subrogation rights place a party in the legal position of one who has been paid money because of the acts of a third party. Thus, the subrogee stands in the shoes of the subrogor and is entitled to all of the rights of its subrogor, but also suffers all of the liabilities to which the subrogor is subject. In subrogation, the subrogee, now in the same posture as the plaintiff subrogor, acquires all rights as against the defendant wrongdoer and is thus able to bring an action against that party to recover the monies it paid. So that's what we're talking about here. We're talking about subrogation. So Universal is standing in the shoes of its insured/unit owners. And in doing that, they pled the statute to also try to have, like I said, two bites at the apple in common law negligence as well as statutory negligence. They tried to impute the vicarious liability of others, of third parties, to the defendants by virtue of the statute. They allege that Continental Casualty provides that they need a written assignment to be entitled to attorney's fees. And I have to respectfully disagree with that for a number of reasons. The first of which, and is very, very important, is that the statute that we're dealing here with in this matter is a prevailing party statute. The statute that we're dealing with in Continental Casualty is a one-way fee statute. It is only available to plaintiffs. The insurance companies are never entitled to fees underneath that statute. It doesn't matter if the plaintiff is found to have brought a fraudulent action. It doesn't matter what it is. The plaintiff only has to prove that they have $1 in recovery and they're entitled to all of their attorney's fees. Okay. The second thing is that was an equitable subrogation case. This is a contractual subrogation case. By equitable subrogation, by its very definition, it does not have a writing. There can be no assignment. Here, we have the policy that provides the subrogation rights to the plaintiff. And it also acts as an implied assignment of any rights that the homeowners have because they're the ones that own the negligence cause of action for damages to their real property. The insurance company, this isn't an action between the insurance company and their insured regarding a coverage issue. This is an action, it's a tort action against a tortfeasor. Okay, so it has nothing to do with an insured seeking coverage determination under their policy, which would then entitle them to benefits under this one-way 627-428 fee statute, which was the subject of Continental Casualty. That also had to deal with sureties and indemnification, and those are not matters that we have here. The bottom line is that Continental Casualty has absolutely nothing to do with contractual subrogation and a prevailing party statute. It involves the one-way fee statute that punishes an insurance company, if you will, for failing to pay when they're supposed to. Because plaintiffs have no skin in the game. They can never be liable for fees to the insurance company, even if fraud is proven. The court has to limit the amount of people that get to take a swing at the insurance companies. If they didn't do that, everybody would be lining up alleged third-party beneficiaries, and they'd be filing nuisance suits because the insurance companies have, quote, deep pockets. So the main difference here is that
they didn't step in the shoes of the plaintiff for all purposes, as the stepping in the shoes happened here. In other words,
correct, Your Honor, exactly, because the insured there still retain their policy rights.
Right.
So that was the big difference in Continental Casualty.
I follow you. I was wondering if we could go back to Loftus real quick. Do you, since we don't necessarily, with all due respect to the panel that authored Loftus, we don't have to follow it. Do you agree that there is no cause of action? That they base that on the to roughly stated on the fact that there are reasons for the length. There's another remedy. If there's no cause of action that arises from the language that the plaintiff was seeking to use, then there is another remedy. In other words, there's another way to effectuate the purpose of the statute. But that's not a remedy available to everybody. Isn't that right? And under Loftus, is that a flaw in Loftus's reasoning?
I'm not sure that I'm following, but let me answer your first question, which is, do I believe that Loftus was decided correctly? And the answer is yes. If you take this entire subsection J and you read it in par materia as a whole, it clearly provides that the only purpose of this statute is to grant the association the ability to impose or levy fees or assessments against unit owners for their negligence and for the negligence of these third parties listed in the statute. I think Loftus goes on to say that they're not abrogating any sort of common law negligence action against third parties individually. It's just saying that the person that brings the action, the other owner, cannot use the statute to impose vicarious liability.
I don't want to interrupt you, but I do want to point out you just went below your 5 minutes. If you're welcome to keep going, or you want to save 5.
I'll save 5, Your Honors.
All right, I'll round it up to 5. All right, Ms. Gregor, you ready?
Morning, Your Honors. May it please the court, Nancy Gregoire for UPCIC. First of all, I guess there's no question that we properly and timely used 1.820 and 1.420. So on that part of my brief, I'll rest. Second, if you look at the amended complaint, this entire argument has boiled down to now what our amended complaint says. The amended complaint was brought under contractual subrogation. We have that right under our contract. Count 1 is for negligence against Ms. Mack, and count 2 is negligence against Mr. Crow.
How was the statute utilized in the cause of action stated in the complaint?
Because what we're saying is, and this is what the trial court accepted, Your Honor, what we're saying is you are liable to us for your own negligence and for the negligence of these other actors, these other potential people. And that's why we used, that's what Loftus went off on. We tried 718-111 UPCIC in Loftus, and the court said there is no cause of action for a unit owner or you as subrogee under Loftus. If you look at that section.
In other words, you tried to base a cause of action on 17.111. Right?
No, just a relationship. The cause of action is for negligence. The relationship with these others, I think you lost your voice again, Judge.
Yeah, no volume.
I think he's saying under Loftus, you alleged a cause of action under 718-111.
Under Loftus, we attempted to allege a cause of action under 718-111, and the Fourth District said there is no cause of action. If you look at the statute, that 718-111J is part of the statutory scheme called insurance. And as Ms. Burnell said, what that does is say, under insurance, and it's common property association pays, it spreads the risk of who pays if there's damage to the condominium property or to a unit under the condominium property. It doesn't create a cause of action for a unit owner against a unit owner. That's what Loftus said. It creates the ability in the association to enforce this statutory scheme against unit owners, so that if there is a dispute between the unit owners on who's responsible, the association steps in and enforces this statute under this enactment. So that's what Loftus says. And you know, what's, I guess, roaming around the edges of this is,
you know, I don't want to interrupt you again, but since we've got some technical issues, let's pause a little bit here for a minute and see if we get Judge Atkinson back on the screen.
IT is co-located with him right now, sir.
All right, thank you, thank you. I stopped the clock.
Thank you, Judge.
So you've got 17 minutes to go. And Ms. Bernal, what did I tell you you had? I was saving you your full 5.
Yes, I believe you said you were rounding.
Yeah, I'm going to give you the full 5. You would like 440, but
thank you.
I'll round it up to 5. If you need an extra 20 seconds, Ms. Gorgar, I'll give you the 20.
Thank you.
So just out of curiosity, nothing to do with the OA, but we had some dead time. How do you all like the Zoom saving you driving from Plantation in Orlando? Pretty cool.
It's wonderful.
Yeah.
You know, I don't know if you do any work in the trial court, but Judge Black and I were both trial judges for a long time. I always allowed out-of-town attorneys to appear telephonically unless it's an evidentiary hearing, obviously. But unfortunately, I hear all these horror stories about so many trial judges made you all drive over to a proceeding an hour, 2, 3, 4 hours away. I never could understand that. Now I think Zoom will result in mandatory rules to require judges at the trial level to accept telephonic or Zoom appearance now. So
I think they're terrific. My last oral argument to this court, I did from Denver.
Kind of cool. Were you skiing? I mean, that sounds like a lot of fun.
Oh, I just went out to visit family, and it just happened the oral argument was during that.
Well, I kind of like that.
I know the clients like the reduced fees that they have to pay through Zoom. You know, I don't think we're ever going to go back to actually driving across the state, like Your Honor said. Yeah. It just makes so much more sense to sit in your office and knock out a bunch of different things in one day, you know, one morning.
Well, that's the consensus. So let's do this. I don't want to get you distracted. I know you're focused on your argument, so we'll wait another minute, and then my feeling is, as the Senate Chair, we proceed with the argument, and Judge Atkinson obviously will have the option to go back and look at the video or listen to this disc, and then Judge Black and I we're just lucky we're not having technical issues. I don't know what's going on. That's why I personally am at the courthouse, because we have IT people here. I think he's coming back now. I see a name and a screen. And that's it. You didn't wear the mask. The mask is now producing. It's better than wearing a gag. You can probably still ask questions. All right, we ready to go? I'm going to start the clock, Ms. Gorgar. Here we go.
Thank you, Judge.
So
I know this court is not bound by Loftus and certainly disagree with Loftus, but Loftus analyzed this statutory section and said the purpose of it isn't to create a private cause of action. The purpose of it is to spread the responsibility and give the association an enforcement tool. And that's why when we tried to state a cause of action under 718-111, the 4th District said no. So then you segue to a case from this court. It's a 2004 case, Sherry versus Regency Insurance Company. And it's procedurally almost indistinguishable. It was the Regency Insurance Company paid a claim of one of their insureds and then brought a contractual subrogation action against the unit owner who caused the damage that resulted in the paid claim. The only cause of action was negligence. Regency is a subrogee for, I'm sorry, it wasn't only negligence, strict liability, negligence for leaving the water on while away from home, negligence for failing to properly maintain the washing machine, and trespass by permitting water to enter this other person's condominium. There wasn't a tenant or subtenant or guest or invitee issue in Sherry, but the cause of action is negligence. So that in order to say you're not only liable for your own negligence, you're liable for the negligence of these other folks. That's why UPCIC said, look, in other context, in a different context, a non-litigation context, you would be liable. And we're alleging you're liable to us for that reason also. It wasn't a cause of action under 718-111. And negligence, you know, at one point in the initial and reply briefs, the appellant talks about negligence. The Sherry case was brought under negligence. Negligence is failure to exercise a standard of care that a reasonable person would exercise. That's what's been alleged in the amended complaint in several places, that you are responsible for your unit. And if somebody else is responsible and does the damage, you're responsible for that damage also. That's the only reason that was used.
Can y'all hear me?
Yes.
Okay. Sorry to interrupt you.
You had a question, Judge?
I did, but it was, I'm back now. I'll jump in later. I'm sorry to break your train of thought.
All right, thank you. As far as continental casualty, we didn't use that based on the 627-428. I do a lot of state farm work, and that one comes up all the time. Now I understand the limitations on 627-428. What we used it for is to explain that continental casualty says assignment and subrogation are different concepts. We didn't take an assignment in this case. We were very careful not to. We just used contractual subrogation.
Well, what about the distinctions that were drawn by your opposing counsel? And I'm sorry if I missed something while I was out, but that continental is inapplicable because it was based on the fact that the principal, if you will, the insured still had, if I'm correct, still had rights under the policy, and you can't have both the insured and the subrogee both seeking fees for the same fees.
And particularly with 627-428, because it is a one-way street. It's one of the few prevailing.
So why should that apply here?
Because what the court said is, although we agree that the terms assignment and subrogation are often confused, they remain distinct legal concepts. The question we must resolve is whether for purposes of the attorney's fee statute, obtaining the right to sue the insurer by equitable subrogation is functionally equivalent to obtaining that right by assignment. They're distinguishing between equitable subrogation or contractual subrogation and assignment. Assignment conveys more rights. UPCIC was very careful in this case.
Wait, okay, but I need to follow this. What does that say about this case? I mean, you're saying that says a subrogee can never seek fees under a prevailing party. If the cause of action is based on a statute or a contract with a prevailing party fee provision, a subrogee after Continental can never seek fees. They never have the right. They never step in the shoes.
There may be a way to do it, but it wasn't done in this case. In this case, because UPCIC did not seek fees. UPCIC sued for negligence. There's no right to claim attorney's fees in a negligence.
It's a prevailing party fees, and they lost.
It's only prevailing party fees if there's a contract or a statute. That's why they're hanging their hat on 718-111.
Okay, well then let's go back to that. Under the Diamond Aircraft or Diamond Airport or whatever it is, if you invoke the rights of the statute in order to establish your liability, then you die by the sword that you wielded. If there's a fee provision in that claim, even if the court says, hey, you know what, there isn't even a cause of action here. This is not something that falls under, and I know you might make the distinction, say, oh, well, there is an actual cause of action under FDUPTA because that's what FDUPTA does. But how is that different? You know, they lost under FDUPTA, you lost under 17.111, which you admit was the basis of vicarious liability.
Judge,
what is the basis of vicarious liability then if it's not 718.111? What did you argue in the litigation, in your complaint, as the basis of the liability against the party who is now seeking fees against you?
We sued the two homeowners for negligence.
What is the basis for the vicarious liability of the party seeking fees from you now?
That's 718.111.
That you alleged and that you argued in the litigation.
It wasn't our cause of action, Judge. We only used it.
What is the basis of the vicarious liability that you attempted to allege against the party now seeking fees from you because you lost?
We said that the relationship is under 718.
What is the basis? What was the basis for it? For that liability that you alleged?
718.111.
Right. So how can we say that you did not bring the action under 718.111?
Because all we did was exactly what Sherry allows. We brought the cause of action for negligence against both of the homeowners and said, by the way, because of this relationship, you're not only liable for your own negligence, you're liable for these other parties. Now, I know Loftus hadn't been decided by that time, but under Loftus, we couldn't have even stated a cause of action under 718.
But under Diamond Aircraft, it doesn't matter whether you stated one or not. You tried.
But you first have to make the quantum leap between our negligence causes of action and the relationship that we could, husband and wife, we wouldn't have to use a statute to say you own the car, you're responsible for the driver, the wife's cause of action for loss of consortium. Those don't require statutes. Here, we just use the statute in the same way to establish a relationship, not to state the cause of action. And I know, Judge, I can see you disagree with me, but that is our position. Our position is we did not sue under the statute. We sued for negligence, and we used the statute as a crutch, as a nexus to say, and by the way, the liability for negligence goes beyond you.
Well, let's talk about the language of the fee provision itself. It says actions for damages for failure to comply with these provisions. Isn't the vicarious liability based on a failure to comply with provisions that you quoted at length, verbatim from the statute, both in your block quote and in your allegations? Wasn't your vicarious liability based on failure to comply with those provisions that you?
No, the failure to comply was a failure to comply with a common law, reasonable person standard of care. That was not taking care of the plumbing. We didn't allege anything about the insurance or who's responsible for the insurance payment or whether it's a common expense or whether it's a unit owner's expense. We didn't allege any of that under 718.111J. We just said, look what this says about the relationships among these people. The liability was, just as in the Sherry case, the liability was not taking care of your plumbing. And that's why we didn't bring the claim under 1711. And certainly, I mean, if your honors disagree with Loftus, then I hope you certify the question because I'd like to take this further. We can't state a cause of action under Loftus, under 718.111. And we didn't try. We just said, your liability, your unit owner liability, it's spread because see what this insurance provision says. The insurance provision deals with insurance, not with a cause of action. And so we could hardly state a cause of action under this because it doesn't contain a cause of action, at least according to Loftus.
But so I understand that the argument you're making that there was no violation on the part of the owners of the act, but under the Diamond Aviation case, there was a similar frailty in the argument there, in that. Well, let me go back for a second. I understand what you're saying. There was you didn't allege that the owners committed a violation of the act, to use the language of the fee provision, but on what other basis could you have held them vicariously liable for the tortious acts of their tenants and whatever, the plumber or whatever?
You know, there may have been a way, I don't know, but that's why trial counsel relied on this, because this was the clearest, purest, straightest route to say, and if anybody else was in your unit, you are liable to us for negligence, their negligence also.
So, but you admit that was the route you took. So what distinguishes this from Diamond Aviation?
Well, first of all, I think FDUCPA is practically distinguishable on every basis from every other law in the state of Florida. It's a monster. Diamond Aviation didn't have this exact same scenario, this exact same procedural posture.
Well, let's back up then. Well, keep answering that question, but I'll sorry for interrupting again. But correct me if I'm wrong, but I think the appellant also cited cases that were similar to Diamond Aviation that were not based on FDUCPA, but rather were based on other instances in which a cause of action was brought under a statute and they failed to state it, or it didn't exist, and yet there was still the fee provision of the statute still applied, because that's what the plaintiff relied on to establish.
But that was an attempt to bring a cause of action under a statute. That was an attempt to use a statute to bring a cause of action. And
is vicarious liability a separate cause of action? It has to be pled in a separate count, right?
Vicarious liability has to have some basis, and that's why trial counsel used this, because it created that basis. I don't know what other basis there would be for vicarious liability. I mean, I think you could almost state a common law cause of action for vicarious liability for someone who's living in your unit, but that's not what was done here. But it wasn't to state a cause of action under this statute, because this statute only has to do with the spread of insurance risk.
So let me say where I'm coming from here. I could follow your argument, which I teed up for you, because no one else had mentioned the language of the statute, that there, under the language of the statute, there were no allegations that the owners themselves violated acts. In other words, the cause of action was not based on violation of the provisions, which is the exact language of the fee statute, which I'm sure the counsel for the appellant will address when she regains the days. But isn't there a separate problem in that, kind of almost with disregard to what the language of FDUCPA was, the fact that the plaintiffs tried to bring the action under FDUCPA, that alone led to the conclusion by the Supreme Court that it was brought under the act. It was brought under FDUCPA.
Certainly.
We relied on this statute to establish liability of the defendants, not their tenants, not those defendants, the owner defendants. Yet, not even under Diamond Aviation can we conclude that you brought this action under the act.
If we had alleged that this was a unit owner expense, and the unit owner was responsible for the repair, replacement as determined by the maintenance provisions of the declaration or bylaws, then that would have been a cause of action under this, which again doesn't exist under Loftus. We didn't allege any of those things. We alleged common law negligence, just like in Sherry. You let your water seep into our insured's apartment, and we had to pay our insured. We're contractually obligated to collect that money from you because of your negligence. And by the way, not only your negligence, and then yes, it segued into this, but the cause of action wasn't under this, just the relationship. And that's been consistently our position, and that's a position that the trial court agreed with. Loftus was exactly the opposite. We tried to ratchet under 718.11, and we didn't do successfully. So I guess it's like we can't have our cake and eat it too. We can't lose both ways.
I just wanted to let you know you're at the 2-minute mark, just below the 2 minutes.
But, I would like to mention the Pino case. Some of the cases that were alleged, Patterson, Ormond Beach, Pino did away with all of those things. Under Pino, and this is back to 14420, Pino said, we have an absolute right, and I know that this hasn't been the point of this oral argument, but it was in the briefs. We have an absolute right to exercise 1.420 dismissal, voluntary dismissal, except for this very narrow exception. If we, the plaintiff, had achieved affirmative relief and we were using 1.420 to avoid losing that affirmative relief almost as a fraud. That's the one time that 1.420 cannot be used under Pino. And so a lot of the,
what was the relief that they were trying to avoid losing? It was a Visoli. What's the name of the case? Visoli. So what does that mean? That the plaintiff is trying to avoid the loss of relief by voluntarily dismissing?
There were a series of cases where this court and other courts said, you know what, that's wrong. You got to the edge of summary judgment and then you voluntarily dismissed, and that's wrong. This case has gone too far. That's serious prejudice to the defendant. And Pino, when Pino finally came along, they disapproved all of those reasons: the serious prejudice, the other reasons that the courts gave for 1.420 was seen almost as an aha gotcha by the plaintiff. You let the case get this far and now you're going to make it go away, and you can't be held responsible for fees because you got out just short of that. Pino said, there's one and only one exception to 1.420. It's an absolute right, except if I, the plaintiff, had achieved affirmative relief and then dismiss the case to keep you from taking that relief away from
Ms. Gorgoy, you're out of time, but I will give you an extra 10 seconds to say goodbye.
I think I pretty much said everything I was going to say.
Beautiful, thank you. So that brings us to Ms. Bernal. You've got 5 minutes.
Could you address the language of the statute, the actual fee provision itself? I understand, and I think you probably follow, maybe you do, maybe you don't, my point about the fact that it seems like the Supreme Court in Diamond Aviation disregarded the language of the FDUPTA statute and just said, well, you tried to bring it under the act and therefore you're liable for fees. But let's just say in isolation here, how did they allege that the damages were for the owner's failure to comply for the provisions of the Condo Act?
Well, if you look at the statute, if you look at their allegations in the complaint, they say that the defendant or members of the defendant's family, unit, occupants, tenants, guests, or invitees negligently failed to maintain, repair, or inspect the plumbing fixtures or appliances. Paragraph 9, in the alternative, said damage occurred as a result of the negligence of the defendants or the defendant's family members, unit, occupants, tenants, guests, or invitees in failing to shut off the water. And then they go on in paragraph 10 and they cite the statute and they say defendants are liable for the negligence of his or her guest, invitee, or visitor pursuant to 718.111.11, where it says that a unit owner is responsible for the costs of repair. That's the duty that's imposed here. That's the statutory duty that they're alleging that the defendants have to make due on. They're alleging that the invitees were negligent when they said that the plumber was negligent in soldering the water heater. And when they alleged in that same, when they answered in that same interrogatory response that the defendants are responsible for the negligence of the plumber pursuant to 718.111. It doesn't make logical sense that 2 years ago, prior to Loftus, they filed Loftus trying to impute negligence to a landlord based on the tenant's negligence, and then didn't do so in this case. That just doesn't make sense when it's based on the exact same statute and the exact same language that they've used in the allegations, as well as their answers to interrogatories. As far as the Sherry case goes, the Sherry case does have to do with negligence. It's often cited for the difference between
could you, please go back to Sherry, but let me, again, it says the unit owner is responsible for the cost of repair. Right. So now, by not paying for the repair, that constitutes the violation of Chapter 718. But really, what they're alleging is that the tort was negligence that caused the damage, which led to the necessity of of responsibility for cost and repair. Doesn't that still create a problem about whether the unit owners themselves were violated a requirement of the act?
I don't think it creates the problem because, again, their allegations go back to the defendant's invitees as well. And they're saying they were negligent and their negligence caused these repairs that Universal was then responsible to pay. So because they paid their insureds, the damages were incurred, they incurred the cost of repairs, and the tortfeasor is then responsible for the cost of repairs.
And then real quick, under Loftus, UCIC doesn't even debate that they brought it under the act, and the Supreme Court operated under that not the Supreme Court, but the Fourth District Court of Appeal operated under that assumption. Like what were are we able to know on this record what the differences were between the complaint filed in Loftus and the complaint filed here, if any? I acknowledge what you're saying. They were both brought under the same provision, but. Right.
I've read both complaints, and the only difference was that they also brought a cause of action directly against the tenants.
That's apparent from the face of the opinion. So I'll leave it there. Right. I don't want to go outside the four corners of the record, but that's apparent from the face of the 4TC opinion. All right.
Right.
Sorry, I'm sorry to really go on. You were talking about
I also wanted to get back because Your Honor touched on the wording of 718-303. The wording says each unit owner, each tenant, other invitee, and each association is governed by and must comply with the provisions of this chapter. So not just the declaration or anything else. The chapter is what imposes the obligation, the duty here. So I just wanted to make sure that there was a connection.
But the owners didn't breach their duty.
No, but they're trying to say that the owners are responsible for the tenant's breach of that duty.
And is the tenant's negligence based on a breach of a duty under the act?
That's what they're saying. Yes, that it's based.
Are they saying that, or are they just saying that they were just generally negligent? Are they saying that the damages caused by the tenants were from a failure to comply with the provisions of the act, or are they just saying that the damages caused by the tenants was just common law negligence? Turn your faucet off next time.
I would argue that it's still underneath the act because they're imposing a duty under the act. The duty arises, and Loftus says the duty arises underneath the act. So because they haven't complied with that, and even in 718-303, it says each tenant has to comply with the provisions of this chapter. So if the tenant
technically just went through your time, but I'll give you another 20 seconds to wrap up.
Okay, thank you, Your Honor. There are two ways to award plaintiffs' appellants' attorney's fees here. One is under 718-303 as the prevailing party, which we've been discussing for the entire oral argument. The other part is that when plaintiffs took a voluntary dismissal after they learned of the arbitrator's decision, that should be considered akin to a motion for summary judgment. I know we don't have time to get into all that, but I could just ask Your Honors to read the briefs again. Vically provides one of those exceptions. Rule 1.420 provides the exception to the summary judgment prohibition, rather. So I would just ask Your Honors to please take a look at that.
Well, you're done. You used all your time wisely. Thank you both.
Thank you.